Welcome to this Paralegal College mini tutorial on European law. Today we will be looking briefly at the types of legislation emanating from the European Union and the process by which laws are made there, and their effect in the United Kingdom. Even though Britain is leaving the European Union in 2019, much of what is European law will continue to be of importance to British people, and therefore is of importance to paralegals. This video supplements our written course material in the Foundations of Law module of the Certificate in Paralegal Studies, approved by the Institution of Paralegals, the leading paralegal organisation in the United Kingdom. Like all our Paralegal College videos, we aim to complete this video in 5 minutes or less. So let's begin. One of the questions that concern citizens right across the European Union is a perceived loss of national sovereignty as a result of being in the European Union. However, to imagine that a country has total sovereignty would imply that that country could do exactly what it wished on every single issue of importance. If that were the case, there would be international chaos and a total breakdown of international law and order, with individual states acting as international gangsters. Instead, however, most states have long resolved to work together and to live in peace and harmony, and to do this they have devised a set of rules which most countries adhere to most of the time. We call these rules international law. Therefore, it is a myth to imagine that any country is fully in charge of its own sovereignty. On the contrary, practically every country on the planet is tied to almost every other country on the planet through a series of international treaties and through the principles of international law. The very fact that Britain has signed over 14,000 treaties in the last 200 years proves this. Thus, for example, over 100 years ago, Britain was one of the first countries to sign treaties on copyright law, enabling authors, artists and composers to have the right to earn money from their work when it was reproduced in other countries. Also, it is more than 100 years since Britain signed the Geneva Convention on the rights of prisoners of war. More recently, one of the most important treaties we have ever signed, perhaps the most important treaty, has been the 1972 European Communities Act, whereby Britain became a member of what is now the European Union. By becoming a member of the European Union, Britain agreed to be bound by European law, and as a result by what is now the European Court of Justice. The European Court of Justice should not be confused with the European Court of Human Rights. They are two completely different institutions. Turning to the types of legislation we find in European law, there are three main types which concern us. The first is regulations. A regulation is a set of rules devised by the Commission of the European Union with the full participation of each member state, and it is transposed directly into the law of the United Kingdom and every other European Union state on the day that it is issued. An example of an EU regulation is the amount of electricity a vacuum cleaner is allowed to use. Under the European Union regulation, the maximum permissible wattage of a vacuum cleaner is 900 watts. A directive, the second type of legislation we are looking at, is a set of instructions to each member state to draft and enact legislation which meets certain conditions laid down by the European Commission. One example was the Working Time Directive, which aimed to ensure that workers do not have to work more than 48 hours per week. Initially, the Conservative government of John Major opted out of this particular directive, but the Labour government of 1997 opted in, and so, while Britain remains a member of the European Union, employers are not allowed to oblige their employees to work more than 48 hours per week. A third type of European Union legal instrument is known as a decision, which is usually addressed either to a single European Union member state or to a company or corporation. European Union decisions are binding on the country or organisation to which they are addressed. In addition to regulations, directives and decisions, there are also opinions and recommendations, but these are not in any way binding. Let us look for a moment at who issues directives, regulations and decisions in the European Union. In other words, the structure of the legislation process. The top of the European Union's power structure is the European Commission. This consists of heads of government and ministers from each member state. When wishing to propose legislation, the Commission will be composed of ministers from the government department relating to that legislation from each member state. So, for example, if the Commission wishes to propose a regulation on consumer matters, then it will first convene a meeting of the relevant ministers from each member state, each of whom will have received prior notification of the topics to be discussed. At the end of several such meetings, there will be general agreement as to what form the legislation should take and what the legislation should set out to achieve. The European Commission will, in the course of discussions, also consult non-governmental organisations and stakeholders such as companies and corporations. Even members of the public can express their opinion on a matter. Having reached a decision as to its proposals, the Commission will then pass a draft of the legislation to the European Parliament and the European Council. Note that unlike national parliaments, the European Parliament cannot propose legislation, can only react to legislation proposed by the Commission. Once the Commission proposes legislation, it is for the European Parliament and the European Council to work together to consider the legislation and decide whether they accept it or whether it needs to be amended. If Parliament and the Council cannot agree the legislation is given a second reading, Parliament may at this stage decide to block it if it cannot agree with the Council. The Council cannot block legislation until it is submitted to a conciliation committee where both sides try to come to a final agreement. If no agreement is reached on the proposed new law, either the Council or Parliament can block it at this stage. In practice, the European Parliament and the European Council work very closely together, and most legislation proposed by the European Commission will eventually find its way into domestic law in all the member states. In Britain, many people objected to what they saw as over-regulation by the European Union and were unhappy about the requirement for freedom of movement of peoples into the United Kingdom. They blamed the European Union for this and for other problems and elected to leave the European Union in a referendum held in 2016. Because Britain will be leaving the European Union in March 2019, it is not known at this stage how many of the past rules and regulations which remain in force until that time will continue to be law in the United Kingdom. On the day of leaving, the 29th of March 2019, all European laws will still have force. After that date, it is anybody's guess what the British government, guided by Parliament, will decide. In order to save parliamentary time, we can expect many rules and regulations to be repealed, or at least reduced in effect by the mechanism of the statutory instrument, which we discussed in the last tutorial. So there you have it, European law in all its glory, how it is made, what effect it has, and its uncertain future in the portfolio of English law. I hope you have enjoyed this tutorial on European law, which is part of our Certificate in Paralegal Studies, approved by the Institute of Paralegals, the leading United Kingdom organisation for paralegals. If you would like to enroll in our Certificate in Paralegal Studies or receive further information on it, visit our website at paralegalcollege.co.uk. Feel free to like and subscribe. Thank you for watching. May the law be with you.